If you want to renounce your US citizenship, join the line. You're number 30,001. This is Taking Shelter. I'm your host, Peter Palsen. If you like this video, please subscribe to our channel. On this episode, I'm joined again by John Richardson. John is an attorney in Toronto. He is an advocate, a very effective and vocal advocate for U.S. Citizens living abroad. Welcome, John.
Good to meet with you again, Peter. Thanks for organizing this.
Yeah, so on our last video, John, we talked about the burdens that U.S. citizens abroad can face from the U.S. tax system. And those burdens really are largely a result of the U.S.'s approach of citizen-based taxation, or taxing their citizens on worldwide income, regardless of whether or how much they spend time in the United States. Today, we're going to discuss how some citizens try to avoid that citizen-based taxation by giving up their citizenship. And John, you spend some time talking to people in your practice about this concept of a renunciation of citizenship.
It's become a real problem for people who are dual tax residents, meaning that they're, by virtue of their citizenship, a tax resident of the United States, and by virtue of residence, a tax resident of, say, Canada or the UK or what have you. And it's somewhere between difficult and impossible for people to live under two very incompatible tax systems, largely because of the importance of retirement and financial planning. And basically, the U.S. tax system does not recognize non-U.S. retirement planning vehicles. That's sort of the start of the problem. And that's largely what's behind the renunciation thing.
So you can understand why some people would want to renounce. And to put it in perspective, from my standpoint, I wake up every morning, I go outside, I kneel down, and I kiss the sweet soil of the United States of America. So this is not something I would do, but I can understand why other people would feel the same way about Canada or their country. And in a world of 8 billion people, I can understand how 5,000 to 10,000 people a year would decide they no longer need the benefits or want to live with the burdens of the U.S. citizenship, and so they make efforts to go forward and renounce. How do you frame this issue, John, when people come to you and want to talk about renunciation?
People are not renouncing because they want to, in the sense of not being American citizens. They're renouncing because they really have to in order to protect their ability to plan for their future. So, obviously, the first point I would make to them is, of course, U.S. citizenship has value. They are giving up certain benefits, the opportunity to live in the United States, perhaps set up businesses, etc. But, if U.S. citizenship is starving them out of their ability to maintain a normal financial life where they live, I would say they're really being forced out. So people are not renouncing so much because they want to, they're renouncing because they have to.
Yeah, and indeed, there are a lot of reasons why people renounce and give up their U.S. citizenship. Take the example of Harmon Wilfred. Harmon went on a vacation to New Zealand and fell in love with the country and wanted to stay, but New Zealand would not extend his visa and, in fact, took steps to deport him. So Harmon went to the embassy in Auckland and went through the formal process of renouncing his United States citizenship. And as a result, the U.S. would not let him back in. And so he effectively became stateless at that point. New Zealand ultimately, as I understand, took pity on him and granted him residency status. So, John, this worked out okay for Harmon, but I think this concept of becoming stateless is a very unattractive alternative or option.
I agree with you completely, Peter. I would never recommend, notwithstanding there are people who do it, I think it's a very, very bad idea to be stateless. And, from time to time, I have, chatted with people who say, for example, well, I'm 2 years away from becoming a Canadian citizen. I'd like to renounce US citizenship and wait the 2 years. I would not do that. The truth is that all citizenships have value. And I really believe that everybody does need a citizenship because if you don't, it's going to severely impair your ability to navigate the world and that.
Well, maybe someday in the future, the metaverse will be recognized as a jurisdiction that can grant citizenship. But until that point in time, becoming stateless is a pretty big hardship, and for a lot of reasons. And just to be clear, I think a lot of people might approach this as a tax process with an immigration consequence, and it's really an immigration process with a tax consequence. And so let's just talk about the formal immigration process, John. It is Section 349A5 of the Immigration and Nationality Act, and it lays out a very formal process you have to go through. If kind of way I look at it, somewhat uninformed basis, it seems like a trip to the DMV, except instead of swapping out your license plates, you are taking this very formal oath that you no longer want the benefits and thus the burdens of U.S. citizenship. You have to fill out a lot of paperwork for immigration purposes, and you have to pay a fee of $2,350. And that is the formal process. And largely as a result of COVID, many consulates are not taking appointments for citizenship-based activity or renunciation, and the current backlog for people waiting to renounce their U.S. citizenships are around estimated as up to 30,000 people. So what's the situation currently in Canada, John?
Well, Canada is actually moving. The way Canada works, it operates out of sort of a centralized processing. Oh, this sounds crazy cluster of words. Renunciation center in Vancouver, which handles the whole country, and that was operating fairly smoothly. Although it's always taken, 6 months to a year to get an appointment. In March 2020, it was effectively closed down because of the COVID thing. It is operating now. They are clearing the backlog. I can say that I know personally people who have appointments in the very near future at all of the consulates in Canada that process these, which would be Vancouver, Calgary, Toronto, Ottawa, and Montreal. It is currently taking, I think, probably about a year to get an appointment. For the moment that you get your paperwork in. So it's still a long haul, but it is moving. And that's in contrast to a lot of other parts of the world. UK, for example, I understand is still shut down. Many other European consulates. So this is a really big problem. I think that this has come to the point where, they explain this by saying that, well, the consulates and embassies are closed because of COVID restrictions and that. But let me read you the legal requirement for renunciation, which does not make any mention of having to do this inside an embassy or consulate. It says making a formal renunciation of nationality before a diplomatic or consular officer of the United States in a foreign state in such form as may be prescribed by the Secretary of the State. Now, I would note that yes, that has to be done in a foreign state. Yes, it must be done before a diplomatic or consular officer. But no, there's no legal requirement in there whatsoever that it has to be done inside the consulate. It says also in such form as may be prescribed by the Secretary of State. I don't know if by that they mean form or process. Maybe the Secretary of State could prescribe that it be done inside a consulate, but the results of my research suggest that there is no such requirement even from the Secretary of State. So the bottom line is that, they really should move this to some form of video conferencing in the same way that even citizenship ceremonies have become. For example, one can become a Canadian citizen through video conferencing, British citizen, etc.
Mm-hmm.
It's a problem that really does need to be solved. Unfortunately, a lot of people, I don't know whether it's 30,000, but it's definitely in the multiples of tens of thousands, are really being held prisoner by their U.S. citizenship at the moment.
And John, another challenge I think people have pointed out is this $2,350 fee, which essentially it costs you that much in some cases for something you never really wanted in the first place. The Paris-based Association of Accidental Americans has gone to court to challenge that fee. Basically, they are arguing that freedom should be free.
You know, $2,350 is an awful lot of money in the currency of people who live in certain parts of the world, right? For example, South America or Mexico, whatever, that's an awful lot of money. So this is a real burden, and it is inconceivable that $2,350 fee could bear any relation whatsoever to the cost. And the proof of this is that the cost to become a U.S. citizen, with all the background, work, et cetera, is somewhere around, I believe, $800.
Mm.
And the renunciation thing is, they've got this down to like a 5-minute appointment.
And John, some of the people that are going through this process, they've never even lived in America, right? They were born in the U.S., their parents were on vacation, what have you, or they were born overseas to U.S. citizen parents. It's nothing they really ever personally ask for. They have to wait until the age of majority, 16 or 18, depending on how you look at it, to renounce. And these are, in a sense, the true accidental Americans. Is that a significant part of the client base you work with? Are these so-called accidental Americans, John?
I work with some of them, to be sure, but not as a really high proportion of who I work with. Mostly I work with people who are, they consider themselves to be Americans, and they, need to free themselves to, be free in their financial planning and that sort of thing. What I find interesting about the accidentals is that for them, it's mostly a banking access issue.
Yeah.
They're, because they didn't even know they were Americans, it never occurred to them to file U.S. taxes. And my impression is that most of them do not and have never. But because in Europe, the identity cards have a place of birth, it's made them easy pickings for the banks, right? Who then identify them and create problems for them to have a bank account. And, that may sound theoretical to people, but try living without a bank account, right?
So, John, given the bottleneck in the process and the fees, for example, one might wonder whether there are other ways besides renunciation to get rid of your U.S. citizenship. And I know that can be hard. And I take the case of Mitsugi Nishikawa, who was conscripted into the Japanese army to fight against America in World War II. And the U.S. moved to renounce or revoke his citizenship. And he went to court to keep it, and the court allowed him to keep it on the basis that he was drafted and therefore did not manifest an intent to leave the U.S. or get rid of his U.S. citizenship. In your experience, is there an alternative to renunciation that people can use to make this a quicker, more efficient, or more effective process?
Right. Well, there are alternatives to renunciation per se, which I'll get into in a second. Unfortunately, it will not speed the process up, though, because all roads lead to some kind of an appearance before a consular officer. Let me give you an example. People talk about renunciation. That's sort of the rage, but renunciation is really a form of relinquishment. And there are different ways of relinquishing U.S. citizenship under Section 349A. And one of them is renunciation. We've talked about renunciation, but another one that is common would be voluntarily naturalizing as a citizen of another country with the intention of relinquishing U.S. citizenship. So although U.S. dual citizenship is permissible for U.S. citizens, no problem. And naturalizing as a citizen of another country will not per se result in U.S. citizenship. But those who naturalize with the clear intention of using the naturalization to relinquish U.S. citizenship will relinquish U.S. citizenship. However, after June 3rd, 2004, these non-renunciatory forms of relinquishment still require some kind of notice. From 2003 to 2008, it was filing a Form 8854, but from 2008, it requires actually getting a certificate of loss of nationality, which does involve the meeting with a consular officer. So one, there are ways of relinquishing U.S. citizenship that do not involve renunciation, and these can be attractive for various reasons. But two, if they are undertaken after June 3rd, 2004, they will not sever U.S. tax residency without more.
Well, let's talk about the tax implications of, and we've talked about this as an immigration process with tax implications. Let's talk about some of those tax implications. And in particular, there can be an exit tax. And that exit tax, I think, depends on whether you, at the time of your relinquishment, qualify as something called a covered expatriate. So what is a covered expatriate and how does this exit tax work?
Right. So one, it applies only to covered expatriates. And there are three ways that one can become a covered expatriate, and any one of the three will suffice. The first is a net worth of more than $2 million US on the date of renunciation, and that's assets less liabilities. The second would be if you had an average U.S. tax liability of, this one's indexed to inflation, of approximately $170,000 for each of the 5 years prior to the relinquishment or renunciation. And the third would be the inability to certify tax compliance for those same 5 years. Any one of those would put somebody in covered expatriate territory. And there are two problems with that. The first is being subject to an exit tax. And the second is the problem of down the road making gifts or leaving bequests to U.S. citizens. Now, the exit tax is a very complicated set of taxes, not one tax. But let me just talk about two aspects of it. The first would be a deemed sale of capital property. So in other words, the United States would want to tax you on capital gains accrued but not realized while you were a U.S. tax resident. And the second is, this is by far the most damaging and worrying, is that for people living outside the United States, long-term residents abroad, it requires a full distribution of their non-U.S. pensions as income. So for example, this is really dangerous. Say you had a University of Toronto professor, taught for 35 years at the University of Toronto, and might have a pension of, say $1.5 million, which is not unusual. Believe it or not, if that person were a covered expatriate, on the day before renunciation, under the U.S. rules, that individual would have an income inclusion of $1.5 million, if you can imagine. In other words, $400,000 of tax owing on money they never received. So this is a very, very significant problem, more in the sense of the pensions than the deemed capital gains. The second problem is the inability to make gifts or bequests to a U.S. citizen or U.S. person, because if you're a covered expatriate and you obviously expatriate, and if 30 years later you leave your full estate to a U.S. citizen, that U.S. citizen will have to pay a 40% tax on the value of the estate. And to be clear, that was not the amount on the date of expatriation. That would be the amount that had grown over the years. So the stakes are very high, and people need to do what they can to avoid covered expatriate status. Parenthetically, there is a dual citizenship from birth exemption, and that applies to some people. But you can see that this is a big, big problem.
Yeah, and John, you mentioned a little bit earlier that some people, accidental Americans, for example, may not have been fully compliant with their tax obligations. So let's zero in on this third condition, which essentially requires you to certify that you have been compliant. So what are the avenues available for someone that might not have been filing to try to relinquish their citizenship? Is it going to be 5 years while you build a good tax history, or is there something?
No, not at all. Currently? Not at all. In fact, I would never advise somebody to do that. Interestingly, and I think largely in response to the accidental problem, in September of 2009, the IRS, to their credit, created something called the relief procedures for former citizens. And basically it was aimed at exactly that kind of problem for people who never filed a U.S. tax return and had a relinquishment or renunciation after March 18th, 2010, which, by the way, was the day FATCA was signed into law. What they can actually do is, so they've relinquished or renounced, they've got their CLN. It's a bit of an oversimplification, but if their net worth is below $2 million, they owe less than $25,000 of U.S. tax. They can essentially file all 6 years at once, along with the 8854, and exit the system completely without the stigma of being a covered expatriate. It's a very attractive program. I highly recommend it to those who are able to use it and have helped people use it on numerous occasions.
And John, you just brought up a couple of other forms that I think we should talk about. One is the Certificate of Loss of Nationality, or CLN form. That's an immigration form, but why can that be important for tax purposes? Well,
it's of course proof that you're not a U.S. citizen. And it's not so much, so if you're not a U.S. citizen, it means that you're not a U.S. tax resident. Okay, so it's important for that reason. But secondly, remember a big part of the problem here is all these accidental Americans who have trouble maintaining bank relationships throughout the world. And the way the FATCA IGAs are written, it's very, very clear that if you show the bank a CLN, that's it. You're outside the whole FATCA regime and you're free to have a bank account again and all that good stuff. So, although this is a horrible thing to say, the reality is that the CLN for Americans living outside the United States, or at least for accidental Americans, is probably one of the most coveted documents in the world today.
And those are issued automatically, or do you need to request a CLN to be issued?
They're issued automatically when you go to the consulate and renounce. Okay, when they accept the renunciation, you will, a few weeks later in the mail, get the Certificate of Loss of Nationality.
You also mentioned, John, Form 8854, which the IRS requires you to file as a result of the relinquishment. Talk about that form.
Right. So the 8854 is basically created Section 877A of the Internal Revenue Code. It's a form where when you file, when you do your sort of cleanup filing your final year, it's where you answer questions where you're essentially providing the facts to determine whether you are or not a covered expatriate. So the first part of the form is, very, very simple stuff. And then you list things like your tax liability for the 5 years. Then on page 2, there's a balance sheet where you list all your assets. And if you are above $2 million, then you go further in the form and, calculate the amount of the exit tax. It's a very high anxiety form for a lot of people. A lot of people plan very, very carefully. In fact, I had a call with somebody just before our meeting today. Was concerned about this to make sure that they are below the $2 million. It's the final thing you file with the IRS. It's your goodbye. I'm no longer a U.S. tax resident letter, and here's why I don't expect to be bothered in the future. So it matters, and it matters hugely.
And John, if you bought like crypto a couple of years ago for $200,000, I'm making up numbers here, but now it's worth like $2.5 million. Is it the value today or what you paid for it that it matters for that covered expatriate?
It's the value today. The test is fair market value on the date of expatriation.
Consequences of fudging the numbers, as it were. And this happened to Oleg Tinkoff, who just last year lost a court case, was ordered to pay restitution of over $500 million and served some confinement time because he concealed a large stock gain from the Form 8854 and covered expatriate tax calculation upon his renunciation or relinquishment. So, this is not a question, John, of out of sight, out of mind. There are obligations that you have to satisfy and continue to satisfy when you relinquish.
I don't know whether that case is part of a trend or not. I mean, it may just be sort of a drive-by shooting, a warning to people. I don't know. I mean, the money there was huge, of course, but to be clear, these are not trivial forms, okay? And they need to be signed under penalties of perjury, and they need to be accurate, etc.
Yeah, and I think that for some people, this renunciation and relinquishment process could be one of the more significant decisions they make in their life, and they really need to, it seems obvious to say, but it needs to be a very thoughtful process, and you should collect as much information as possible. A couple of sources of information. Number one, the IRS actually puts out quite a bit of good information. You talked about the process earlier of kind of remediating your prior tax compliance. There's a 2019 notice that talks a lot about that. A lot of frequently asked questions issued we'll link to, and then a 2-hour webcast or webinar the IRS put together on the tax implications of the process of relinquishing your US citizenship. So they really put out a lot of good material in this area, informative material. I think I'd be remiss not to mention Andrew Henderson in the Nomad Capitalist. Andrew is himself, he relinquished his US citizenship, moved outside the United States, and he has a channel that puts out a lot of videos, including a lot of videos that talk about his own renunciation process and the outcome of other people he knows that have renounced that come on his channel. And he had a process or a video the other day that talked about if you renounced and then you later decide to come back to the United States, what opportunities do you have to follow the immigration processes that apply to any non-US person to try to come back in? Because I think, John, the point is that renunciation is effectively a fairly irreversible process. Would you agree? Yeah, you made another good point, John, that renunciation, relinquishment is kind of like not an absolute forget about the IRS for the rest of your life. I mean, particularly if you've got pre-renunciation tax obligations or delinquent taxes or something. But the other point is that if you have real estate in the United States or you have certain business activity in the United States, that is not going to be, in a sense, shielded from ongoing U.S. tax just because you relinquish. You'll be standing aside all of the other non-residents that have to pay tax on certain amounts of U.S. source income or real estate gains. So this is not kind of a way to just completely cut ties necessarily with the IRS.
Yeah, that is absolutely correct. And one of the first issues that I explore with anybody wanting to renounce U.S. citizenship is, what is their financial relationship with the United States anyway? Because, if all of your income is U.S. source, for example, you've got to understand that you renounce, then all of a sudden you become taxed as a non-resident alien, right? Mm-hmm. And, for certain types of income streams, that's a flat 30% tax. But, a potentially even more dangerous thing is the U.S. estate tax rules. So let's imagine that you own personally, and there's a whole industry, as you know, which is, aimed at helping people understand how to own assets, shield them from U.S. estate tax, right? But, let's say you own, some small apartment building or something, and you cease to be a U.S. citizen and you die, then the way the U.S. estate tax rules are written is that everything above $60,000 is subject to the U.S. estate tax rules, and that's a lot of money. On the other hand, if you're a citizen, at the moment, the moment is what, $11 million exclusion, I think going down to $5 million, but the point is that it's considerably more. Mm-hmm. And, one piece of advice that I would give everybody, and, certainly I try to do this with people, is, you have to understand what your financial relationship with the United States would be if you do renounce. And the more assets you have in the United States, I think the more carefully you should consider the renunciation decision.
Yeah. And when's the switch flip, John? Is it the date that of the CLN? I guess you get your certificate of loss of nationality that has a certain date at which you went and renounced and took the oath. Is that the date that this status shifts from citizen-based taxation to non-resident taxation?
The effective date, although isn't confirmed until the CLN is issued, is the date that you went to the consulate and asked them for the CLN, so to speak.
Yeah. So it just seems pretty obvious that people that are going to take this path need to get a fair amount of advice, both from the immigration standpoint and a tax standpoint. So to wrap this up, John, let's say someone wants to renounce today. What is their really first step or next step, and what should be their expectations of timeline?
Well, I think if they want to renounce today, the first thing is to get in the paperwork to request the appointment. It's going to be a long wait, and the other issues can be cleaned up, in the interim, right? So, the first thing I do is, if they're clear they want to renounce, is, we get the appointment request in. I mean, you can always change your mind, but at least, you're in the queue. Then the next thing is to worry about, is the person going to be a covered expatriate, right? So that involves looking at net worth issues. It involves looking at tax compliance. In most cases for Americans living outside the United States, the tax liability test would not matter because they're paying sufficient tax in, say, Canada or the UK to generate, huge foreign tax credits, right? And kind of go from there. I would say that the percentage of people who, who've been filing the taxes and where their taxes are done correctly or defensively is not high, because there's just so much going on. In many cases, remedial work is, a reasonable thing to do. And, all this sort of stuff gets done step by step. I mean, the goal is to get people out of this without being covered expatriates, and that can involve net worth reduction in the form of gifting, et cetera. So, I mean, everybody's different, but I think the thing is they need to get started. I do not see this getting easier, and one of the problems with this delay in the renunciation thing, bearing in mind the $2 million net worth test, is that this delay is creating, coupled with the inflation in real estate, that is creating a lot of covered expatriates. They never would have been covered expatriates before, right?
Well, and crypto and other assets that have done
well. Or even just the family home. It's interesting that, it's partly this environment of low interest rates. But, a lot of these people, don't start with a lot of margin anyway. And by the way, to be clear, these are not wealthy people, right? These are just people who have, pensions or a house, and these things are, added in as part of the whole net worth test. They have no access to money. but
liquidity.
they're caught up in this problem.
Well, John, I appreciate you coming on the channel and talking the viewers through this process and more details of the process, a very involved process that should be a thoughtful process, both from an immigration and tax standpoint. If you like this video, please subscribe to the channel. This has been Taking Shelter. I'm your host, Peter Palsen.